The next matter to come before us this morning is in re DT and MT. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know, I am keeping the clock this morning.
And Judge Hensel?
Yes.
I'm sorry for interrupting,
Okay.
but on this case, especially with the names of juveniles,
Yes.
they don't want to mention.
Right. Please do not use the names of any victims or juveniles as you are presenting your oral argument, as we are streaming live on YouTube, and the recorded argument will be available. The judges have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Ready? Yes, Attorney Dave Lowry for appellant, father, Michael Townsend, 00311017. Thank you for the opportunity to discuss this today. I was appointed to represent Mr. Townsend's interests from the Juvenile Court for Summit County, Ohio. I did not participate or represent Mr. Townsend in the underlying case. That was a separate counsel. I've had a chance to review what is rather a voluminous amount of material. This case goes for several years, and as a result of that, I've presented a couple of assignments of error. I think one of the assignments of error that I presented, perhaps I could have delineated it a little bit better. I think that more appropriately, assignment of error number one and assignment of error number two, because of the issues with the case plan, could very well have been that the trial court errs when it makes a decision based upon a case plan in a juvenile court proceeding that has not been adopted by the court. And I think perhaps that may have been a better actual assignment, but I do incorporate that idea or that concept within the body of assignment of error numbers one and number two. This is a case, as indicated, that goes back for a significant period of time. The children, there's two children in this case. They were taken from mother and father for various reasons, as set forth in the shelter care documents and the complaints that were originally filed. Immediately after placement outside of the parents' care, the children were placed initially with a kinship placement, which ultimately didn't work out due to the cleanliness and some other issues at that facility, and they were placed in foster care. The parents' visitation was established by the agency, and it was essentially 2 hours at the visitation center, the FIC is commonly referred to, beginning when the case started back in 2016. The principal issue that I have, and I assume that this court perhaps is seeing quite a bit of this due to COVID and some of the other issues that have presented themselves over the last couple of years, is the concept of reunification. As I indicated in my brief, the state obviously it's incumbent upon the state to try to reunify children with their parents. That's a case plan objective. It's virtually always a case plan objective for the most part, and it was indeed in this case, in this particular matter. The interesting thing about this case is that the multitude of case plans that were filed in the case for various reasons, but predominantly the final case plan that was filed, and I allude to that, and that was filed back in 2020, or I'm sorry, that was filed on August of 2020. During this entire period of time, the way the visitations worked were that the children would have 2 hours with my client and 2 hours with mother. Mother and father were separated and apart due to some domestic violence issues. The way they had the visitations working for the most part was that the placement of the children was out of town, and it was a significant trip in order to get them to the FIC. In fact, I believe if you look at the record, it was over an hour to get them there, an hour to take them home. The way they had it set up was the children would see mother first, and then immediately thereafter they would see father. So the transition of the children was from mother to father. Subsequently, as indicated in this case, it's clear that mom didn't care, and she voluntarily relinquished her interest or her rights to her children and let the case go forward on a permanent custody motion which was filed by the state and heard by the trial court. During that period of
Counsel?
time, my
Counsel,
would-
you said that I'm sorry, I don't mean to make a point of this, but I feel like I have to. You said she doesn't care and she relinquished permanent custody, relinquished her rights to permanent custody. But an alternative argument might be made that she really did care and she knew it was not in the best interest of those children to be with either parent. So that's why she relinquished permanent custody.
I think if you review the record, you can, someone would have perhaps their own opinion about that, but I understand what you're saying. I guess I'd ask the court to take a look at what mom did or didn't do under the various case plans to make that ultimate determination. But regardless, my client would inherit these children after they had visited with mother, and it was a very traumatic episode from the way that it was originally set up. During this period of time, if you take a look at the case plans, and that's set forth in my brief, there's a first case plan, second, third. Ultimately, there were 4 case plans put in place. Father had virtually no obligations under any of the first case plans. 8 case plans were established by the state. Basically, it was to obey all laws. It was to do what he had to with respect to a misdemeanor criminal charge in municipal court. And he was in absolute compliance with the case plan objectives in those case plans. There was a first permanent custody case in this that was in this matter, and that was heard by the judge. And as a result of that original hearing, the court found that there was substantial compliance, and the court did not grant the permanent custody motion of the state. That was held in a trial before Judge Teodosio on August 31st, 2018. Of interest in that decision, on page 2, paragraph number 7, the court makes the specific finding that one of the problems in the case was that the state was arguing what father had not done when there were no case plan objectives to that end. And the court was very clear when it says the case plan was never amended to include recommendations made as a result of an evaluation. It says further, if you take a look at that, while there are outstanding concerns, SCCS has failed to amend the case plan to address those concerns, which has limited the ability of the parents to achieve reunification. So the court very clearly says, listen, without an amended case plan, you can't come into court and say, hey, listen, this person didn't do this, this, and this, and therefore it's in the best of the children to be taken from the parents because we've tried to reunify, when those issues haven't either been approved or delineated by the court in a case plan. And that argument has been followed by this court in re S period D-M, which I cite. It's this court, 2014 Ohio 1501, which is a case where this court said at paragraph 25, because these matters were not added to father's case plan and were not otherwise made in order of the trial court, father was not and should not be bound by them as comprising his case plan. It's more than apparent that the final case plan, which established the basis, if not all, of the recommendations upon which the state relies in order to pursue its permanent custody case, were added to the August 2020 case plan, which was never approved by the court. It never became an order of the court. Why, I don't know. If it was some sort of an oversight, obviously it was an oversight. So the issue then is that has the state really tried to effectuate reunification when it relies upon case plan objectives that have never been approved by the court? Now, the state, I know, is going to come back and say, well, you know, he may have assented to it, he may have signed it. That's not the point. Case plan objectives do not become an order of court until the case plan is adopted by the court. That's case law, that's statutory law, that's the law of the state of Ohio. That
Counsel, what about the fact that the court made a determination before the case plan that you're talking about, that made a determination of reasonable efforts?
Because all those reasonable efforts were based upon case plans that had nothing that my client was required to do. That's the twist here. That reunification, I mean, that reasonable efforts determination was made before that August 2020 amended case plan, which set forth all these whistles and bells that my client had to abide by. That's the twist. Because once again, those case plans contain virtually no objectives for my client. So in terms of have they done reunification? The court looked and said, well, look at these case plans. Here's the case plan objectives. This is what the SCCS was supposed to have done, and it wasn't an issue until the 8/20 amended case plan that was never adopted by the court. And every one of the criteria that the state, the guardian ad litem, and everybody relies upon is that 8/20/20 case plan and the objectives that are contained therein. And once again, I mean, reunification. This is a period from 2016 to 2020 where my guy has been in virtual compliance with case plans, and no one ever said to him, okay, we're going to give you a little bit extra visitation. Okay, we're going to stop doing closely supervised or monitored visitation. And then if you look at the file, the red herring in this thing is these multiple motions that are filed by people alleging sexual abuse, which obviously Judge Teodosio was tired of hearing about, because multiple times in the record, she comes out and says, listen, we're not going there. There's been no basis.
Counsel, I need to let you know that you have about 4 minutes left, and I don't know if you wanted to reserve any. You may continue to reserve, but I wanted to let you know that.
I will. Let me just finish up here. My client did, and once again, the state's going to chip away, but my client is involved, has been involved. He has done an enormous amount of things during the period. There's always this thing, well, he went into the counselor and said this really wasn't helping him. I mean, that's part of counseling. The bottom line is my client worked his butt off, whether, it was with strict compliance or whatever, but I'd ask the court to take a look at that. But more importantly, I think there's a real issue based upon this court prior determination in the case I cited, that the reliance upon these things is inappropriate and it's not proper in a situation like this where those orders upon which the court relies are made last minute and never adopted or approved by the court. Thank you.
Thank you, counsel. Counsel for the state.
Yes, thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of Summit County Children's Services, which is the appellee in this case. And just a couple points right off the top, talking about the case plans. And I know we've belabored this a great deal in this case. One initial point, as this court is well aware, and which we have both briefed in our briefs in this case, the case plan compliance is not necessarily dispositive in any case. However, there was a case plan adopted by the court. It was filed on April 24th, 2017. It was adopted by the juvenile court in May of 2017, and it actually imposed the following objectives upon father. He was, of course, to continue with closely monitored visitation. He was expected to abide by the law and clear up his criminal charges, which included the domestic violence against mother that caused these children's removal in the first place. He was supposed to follow the probation rules that had been imposed on him by that court in that case, which included anger management classes and drug screenings. He was also required to complete a parenting evaluation at Summit Psychological Associates and to participate in counseling for the purpose of gaining insight into his behavior and how those behaviors affected his family. He was also, of course, expected to attend all court appearances and sign releases. Okay, so that was not only approved of by father, but it was actually adopted by the juvenile court in this case in 2017. There were also a couple of additional case plans that were amended. I've got at least 2 other amendments to the case plan, both of which were adopted by the trial court. And to correct the record, the August 26, 2020 case plan to which we referred, which was the last case plan, was actually adopted by the court as a court order in a September 16th, 2020 journal entry. So it's not exactly accurate to say that there were no case plans that had any objectives that were specific to father and required him to follow up that were ever adopted as court orders. They were. And I went through this case and checked every single one of those case plans to make sure that they were adopted by the trial court and were enforceable. However, we still have to look at I mean, the basic issue of this isn't whether father checked off the boxes on what was expected of him in the case plan. As witness after witness testified in this case, the important issues, and this is why you put on a case plan in the first place, the important issues were trying to address the reasons why these children were removed from the house in the first place, and that was domestic violence. And yes, as counsel relates, father worked hard at checking off the boxes of the case plan, and he did, as is noted in the briefs, attend, for instance, not 1, but 3 anger management classes. However, he completed 2 anger management classes, including a very intense one, before he engaged in another domestic violence incident against the mother and also punched his girlfriend the following year. So, you know, this was one of the concerns by every person who testified, who was a professional, for instance, a counselor or a psychologist or the caseworkers or the guardian ad litem, was that—
Counsel, I'm just going to pause you for one moment. Mr. Lowry, some of the documents which I know you are diligently reviewing in preparation to your rebuttal can be seen on the screen.
Oh, I'm
So
sorry.
I understand technology is a crazy thing, and we can't really see them very well, but they may contain some information that we don't want. So if you wouldn't mind, if you just be mindful of that. Counsel for the state,
Oh, okay, thank you.
Sure. I apologize. Please continue.
That's all right, Your Honor. Trying to get back on the track of my train of thought. But the sum and substance of all the testimony was that, yes, father has done a lot of checking off the boxes to try to comply with his case plan, but he didn't follow through on the portions of, or on the goals and objectives that were really the keys to this case. And that was addressing his propensity to commit domestic violence against the significant others in his life. Okay, as shown by the fact that he had 2 more instances of domestic violence during the course of this case, even after having taken intensive anger management classes. But more significantly, he refuses to acknowledge, even after counseling at Summit Psychological in 2018, and by the way, his refusal to acknowledge his problems was one of the reasons Summit Psychological discharged him from treatment. You know, his refusal to acknowledge the problems means he's going to be blind to his own problems and his children's problems. He continued to test positive throughout this case to drug use, even though it was part of his probation and even though it was part of his case plan to follow through with that. And and so it's the question then from all of the witnesses collectively was, even though father has done all these things, what has he learned that he would apply to himself and to promoting the welfare of these 2 children who, despite father's statements that he doesn't think they have any problems, have demonstrated significant behavioral problems. And so, one of the psychologists who testified said that there's a question as to whether if these children's problems are not recognized by father, that they will ever be addressed if they were in father's care, and whether they would wind up with their, if their problems were unaddressed and unremediated, whether they would wind up permanently having significant emotional and behavioral problems as adults that could cause them, problems down the line. And so that was the sum and substance of the testimony. But I would also remind the court, getting back to the particulars, okay, of the best interest of the child determination and the case plan, I will remind the court also, we also have, in addition to the case plans that were amended and adopted by the court, we also have a February 2018 magistrate's decision that's separate from a case plan that ordered father to undergo substance abuse evaluation and follow treatment recommendations, which he never got, and continued to test positive for drug use throughout this case. So what the juvenile court did was the juvenile court followed the statute, 2151-14, which looks at, first of all, how long, these children have been in temporary custody for well more than 12 out of 22 months. Then it also applied the best interests of the children factors, looking at the children's interactions and relationships, which would include their behavioral problems that seem to be being addressed and remediated while they've been in temporary custody. The children's wishes, even though it's father's suspicion that the children's feelings of being upset, possibly during their visitation with their mother, bled over to father because his visitations followed immediately after mother's visitations. Even after mother's visitation ceased, the children still did not want to visit with father. The children's custodial history, they were briefly in the care of a grandmother during the course of this case, but have never been back in the care of either of their parents. They have a significant need for a legally secure placement, and that they've been able to have so far with the foster family that did express at the hearing a willingness to adopt these children. Plus, then there are the additional factors that are contained in 2151-414E. The ones that are significant to this case and relevant to this case are the parents' continuous and repeated failures to remedy the conditions causing removal. And that's not dependent upon working a case plan. That's, have you continuously and repeatedly failed to remedy the conditions that cause the removal? That would be the domestic violence. And then there's the parent's chronic mental or emotional illness or chemical dependency. That again is not necessarily dependent upon following and checking off the boxes of a case plan, but father clearly has chronic emotional illness. He's got several personality disorders that he does not believe he has or does not believe are significant. And he has a chemical dependency problem. I mean, his diagnosis of personality disorders includes severe drug and alcohol dependency disorders. So these are things that remained unaddressed. And yes, father has done a lot of things. He went through counseling in 2018, but again was terminated because he didn't think he needed it. He, at his parenting evaluation in 2019, that was where he was diagnosed with the personality disorders, presented a fake good profile, meaning he views himself as mentally healthy and virtuous and rule following. He downplays his significant history of domestic violence and substance abuse, denied that the children have behavioral problems, and did not follow through with the recommendations of drug treatment, further counseling, further parenting classes, because this all upset father because he's undergone some parenting classes and believed he'd done everything already. And yes, father had indeed sought some additional counseling through the battered women's shelter and a program called Man to Man, but did not make any of that known to children's services until it was too late. Addressing the second assignment very briefly, because I know I'm probably coming close to the limit of my time, is that the juvenile court again did not lose its way in finding that the agency made reasonable efforts to reunite this family. First of all, at the permanent custody hearing, because it had already made that determination in December of 2019, it really didn't have to make that determination again at the permanent custody hearing, even though it did. And I've cited the authority for why that is the case. But looking at what Children's Services did, it did give father a detailed case plan as early as 2017 and amended it twice, concerning father. All of those case plans and amendments to case plans were adopted by the trial court as court orders. It made multiple referrals for father to obtain services and to be evaluated, including to Coleman Professional and Summit Psychological. And also did check with Summit Psychological to find out whether father's claim that he was denied additional services from Summit Psychological due to payment or non-payment of a bill. It turns out that wasn't exactly correct. But yeah, referrals to Coleman, referrals to Summit Psychological for counseling and parenting evaluations. And regarding the visitation, finally, I would remind the court that visitation was never reduced in monitoring. Wasn't relaxed, I should say, further from being monitored or closely supervised. Father was never permitted to have visitation with the children overnight in his home. But I would note that in 2020, father did make a motion for increased visitation. And the reason the court denied it was that father did not appear for the hearing. So, these were Summit County Children's Services did make reasonable efforts for father to reunite these children by trying to make reasonable efforts to remediate the reasons why these children were removed in the first place. And it was not against the weight of the evidence that the trial court found that twice. So unless there are some other questions by the court, the agency would rely on its briefs and ask this court to affirm, but I'm open for any questions by your honors.
Seeing none, and that was perfect timing, counsel, so thank you.
Thank you very much.
Counsel for the appellant, you have 3 minutes and 20 seconds remaining for rebuttal.
Thank you. Just 3 issues I'd like to go over real quick. The issue with Coleman and Summit Psych is talked about in my brief. It's in the record. My client tried to go to Summit Psych. They wouldn't accept him because there were issues with a past due billing that wasn't his responsibility or what, and there was attempted to be resolved. He went to Coleman. Coleman wouldn't see him because SCCS couldn't get them records. They acknowledged that was their fault in the record. He and then subsequently went back to Summit Psych. So, that whole thing was orchestrated by the agency, and he did. He went Summit, Coleman, Summit. The state indicating that he was terminated because he indicated that he didn't need treatment and didn't want treatment isn't supported by the record. I discussed that. The actual fact of the matter is that the individual that he was seeing at Summit Psychological indicated that there was terminated because they were unable to form a individual counseling relationship, and that's in my brief, and that's a specific citation to that effect. The other issue that I wanted to talk about was this issue that he filed a motion for visitation. I understand this is an ex parte proceeding. I've spoken to my client, and there are reasons why he didn't show, and it was a notice issue, or he would have shown. But I guess that begs the broader question: is it incumbent upon people to have to file motions saying, "Listen, I want more visitation"? That's what the agency should be doing. And there was a period of time, if you review the record, for 2 years, that my clients' visits were going very well. They were fine. There was no issue with them. Every time it appeared that they were going to be more lenient, this issue of the sexual abuse came forward and screwed up the whole transition, and screwed up his procedure. He'd lose several months of visitation, and then it would either go back to closely monitored or closely supervised, or he would just be denied visitation. Finally, I have to correct myself. I made an error, indicated an error. The amended case plan that was not approved was the 12/21/2018, not the August 2020. That is the case plan that includes and has all of the obligations upon which the state ultimately relied to obtain PC. I would note that counsel says there were other case plans. Every other case plan that was filed, essentially the amendment was based upon a change in circumstances or something having to do with mother. For example, one was that she gave birth and there was fentanyl on board. Another one was, based upon various other things. So the other amended case plans didn't go to or speak to situations with my client. The only one that really spoke to his issue was this 12/2018, and that was the case plan that was never approved. So with that said, thanks for your time. That was pretty close. I hit it right on the head. My internal clock still works. Thank you, and I appreciate your indulgence in listening to our case here today.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Have a great day. Thank you.
Thank you.